Shell will have to wait a little longer to find out if its license to do a seismic survey of South Africa's wild coast is approved. The High Court in Makhanda dismissed the company's application for leave to appeal an earlier ruling that temporarily halted the project. The interim order was to allow for an application by wild coast communities seeking to have Shell's exploration license reviewed and set aside. Shell has stated its plan to carry out the seismic survey between December this year and May of 2023. Joining me now is Wilmien Wicomb, attorney at Legal Resource Centre, just to unpack this for us. Wilmien, from what we understand and this particular ruling, what can we get from what we have now heard from this ruling?
Well, to be honest, not much, and that's why the very attempt by Shell to appeal this interim interdict was fairly strange. So, as you rightly point out, the communities brought an application to have the permit issued to Shell in 2013 set aside, and that's the permit that allows them to do these seismic surveys. The interim interdict was granted in December, and so Shell has now tried to get that interim interdict set aside, but or at least for them to get the chance to appeal it. Now, even if they could appeal it, and even if they won, it would have made no difference to them because, as you rightly point out, they have indicated, because of the prevalence of whales and other issues on the wild coast, that they could only commence in December this year.
Now, of course, with this latest court ruling, where does this place the matter now?
So this is really just about the interim interdict. So Shell being stopped while the court considers the granting of the actual permit. Now, that granting of the permit, that will be heard at the end of May. A couple of months later, we will have a judgment, and then we'll know whether the communities are correct in saying that that permit was granted unlawfully. If that is the case, then it's back to the drawing board for Shell.
Sure. This has become a court matter, but it actually really is about the company exploring oil and gas deposits really around the wild coast. What negative impact could this possibly have for those that live in the community?
Well, so a variety of things. And I think the one thing that one must make clear, and that makes this kind of litigation quite difficult, is that it's incredibly expensive to research the precise impacts of these seismic surveys. And for that reason, there isn't enough research for us to know what the impacts are. But there is enough to suggest that the impact on the ecosystem and on marine life, bird life, will be very, very serious. And so, of course, for these communities, they not only live off the ocean, they are fishing communities, but they also, rely on their connection to the ocean as central to their identity and cultural expression. They see themselves as, as caretakers of the ocean. And so for them, it was a shock that this permit was granted and Shell was going ahead without anyone notifying them of this at any point. So they have real concerns of what the impacts of this survey will be on their ocean, as they should be.
And so we have seen that, we have seen really that it's interesting that Cabinet has not really said much, but it seems as though they are on the side of the private company and not of the people. What do you make of that?
Well, that certainly has been the explicit attitude of Minister Gwede Mantashe, and he has said some horrible things about our community clients, and he also recently said that this kind of litigation is stopping investment, etc. So, of course, the answer to that is that if these companies were acting lawfully, then they wouldn't be taken to court. And I must say, in both the Shell application and even the one currently ongoing on the West Coast, it is clear that the minister, as regulator, is not communicating correct information to potential investors, which is also, in a way, getting them into these kinds of messes. They're trying to fast-track applications without following the law. And I mean, that's simply not something that we can allow, and I'm sure all South Africans will agree with that.
Do you foresee this matter, Wilmien, being in the courts for quite some time?
Yes, I think certainly that there are two currently ongoing, and I think we'll watch with interest what happens in the next year or so. The interesting thing is also that both the current applications on the Wild Coast and the West Coast, that they had to do with a transition in our legislation from a previous environmental law framework to a new one, and it's as if these both on the West Coast and Wild Coast, these surveys kind of fell between the gap between these two frameworks. So hopefully, once there's absolute clarity about which framework is in place, we'll start, closing these loopholes, and we won't have to go to court all the time.
So the issue, you talk about this gap that you speak about. What is this gap that you're referring to at the moment that is still within the courts and that could possibly take us there for much longer?
So we moved from an environmental law framework that placed the responsibility for environmental regulation on different departments. So it used to be the responsibility, for example, of the Minister of Mining. So we've moved to a unified system of environmental regulation. And this was done through the change in laws and change in regulations. But because we're still kind of in this transitional period, that's the problem. And that's how companies are saying, well, these new frameworks, they don't apply to us because we've been trying to get the permits for a while. So that's the problem, and that's hopefully what will get sorted out with these kinds of cases.
Now, in a situation like this, Wilmien, what could possibly be the best case scenario, if there is, for any of these parties?
The best case scenario, for sure, I would say, is if we all accept that the law requires a proper environmental authorization, environmental impact assessment by the companies, and that they conduct those proper assessments, and that they stop relying on the absence of evidence to say, well, that means everything is fine, but that there's some real investment into an understanding of what the impact of these surveys are, in particular, in light of the extraordinary explosion of extractivism in our oceans, in particular on the West Coast. It's kind of the new frontier for extractivism. And in that context, it's really alarming for all these exploration and mining to go ahead without us having a clear understanding of what the impact will be. And, once the ocean is gone, it's too late to then realize what the impact has been.
And so what can we then expect next in this particular case?
Next up, it is theoretically possible for Shell to try and appeal the interim interdict again to the Supreme Court of Appeal. I think it's unlikely that they will do so, but the possibility exists. But otherwise, we wait for the full hearing of the legality of the permit that will happen at the end of May, where all these issues will be thoroughly raised and considered by the court. And I think we all look forward to having that kind of clarity that we hope a court will give us during the course of this year.
Wilmien Wicomb, attorney and at Legal Resources Center, thank you so much for your time this morning, for giving us some clarity of this matter.